You have 14 incredible questions, yeah. Certainly.
The lady asks about such courts as the Fair Courts and the Beth Din, which is a Jewish religious court, how they enforced their decisions. The question is well pointed because it's frequently asserted that without that sheriff, without that man with a gun, you can't enforce court decisions. Now, this is nonsense. Prior to 1920 in this country, it was impossible in any court that I know of to enforce an arbitrator's award. It was also completely unnecessary. The president of the American Arbitration Association told Mr. Wooldridge, who wrote the book I recommended earlier, that in all his experience prior to 1920, he had never heard of an arbitration award being violated. Why? It's easy enough to figure out. Let's assume that one of you is in business. I have a dispute with you. We go to arbitration, and it turns out that after the decision has gone against you, you won't pay up the judgment. Well, I'm not going to come after you with a gun. I'm just going to tell everybody. And if you think that won't work, I have a recommendation to you. In any standard encyclopedia, look up the history of a man by the name of Thomas Boycott. Thank you. Yes, sir. Appeal. I think I understand your question. And in fact, it constitutes the best argument for world government I've ever heard. The question is, however, a reasonable one. If I understand it properly, the gentleman wants to know what happens in the first place, in the question of courts, if the person against whom the decision goes believes he has really been rooked, that the court has made a mistake, and he wants to try again. He wants a second bite out of the apple. What do you do on appeals? Second question is a little off the point of my talk and has to do with competing armies. Well, the military lecture was yesterday, but maybe both can be answered in one answer. I assume again, and I think it is reasonable to assume, that the same thing will happen in the future as has happened over the past 800 years. First of all, it's a mistake to think that appeals have always been available. They haven't. The appeal from one court to a higher court is in our jurisprudential history a relatively new thing. The state of Georgia, for example, if I remember correctly, had no appeals courts up until around 1830. In England, you had no appeal in criminal cases up until around 1850. You got one bite on the apple, and that was it. And we managed to survive. Now, I'm not saying that's the best way to do things, but a society can function. You can get a reasonable brand of justice that way. I presume, however, that having found with our experience with appeals that a man should be given 2 bites on the apple, that we will wish to continue this in a libertarian society. How are we going to do it? We're going to do it the same way. Those arbitration panels, or whatever else you want to call them, those courts, realizing that there is a market for review of judicial decisions, are going to provide it. They're going to provide it themselves in their own self-interest. They will form an appeal board. If you say, well then, where do you go from there? The only answer I can give you is today, when you fail in the Supreme Court of the United States, where do you go from there? God? Sir?
There should be relatively few appeals in commercial transactions because of the expense involved.
Gentlemen, you can have the platform next week between 3 and 4 on Monday morning. I happen to agree with the comment that was made. There are relatively few appeals. It is the case, for example, that in 24 jurisdictions of the United States today, an arbitrator's award is enforceable as a matter of law in the courts. That means in the remaining 26 it is not. My data is from 1968. I have not been able to find any substantial number of appeals from the arbitrator's decision to the law courts in any of these jurisdictions. When I have found them, it has been invariably on the basis not of an error on the part of the court, but alleged bias or fraud. It just does not seem to happen. Sir? A very good point, sir. Well, maybe in your contracts you can afford 2 or 3 appeals, but I can't. But the point is well taken. There are relatively few large-scale commercial contracts made today, which do not contain procedures for ironing out their differences. To give you an example of what I mean, the Uniform Commercial Code, which is a codification of the old law merchant and the Uniform Negotiable Instruments law, exists in all our jurisdictions today, provides that the parties to any contract may specify certain conditions of that contract. They may specify that it will be taken to arbitration, and if so, they can specify that it will be decided under the laws of a particular jurisdiction. This already exists. I expect it will continue to exist. I would suggest to any of you who are in businesses where this is applicable and practical that we take up the gentleman's suggestion. Think in advance. People make honest mistakes. The consequences are just as bad sometimes as if they're dishonest, but they are going to happen. Do not assume that because you and your neighbor know exactly what you mean when you're speaking about a Holstein cow, that it will be impossible when you sell one to have any difficulty later on. You'd be astonished. You can have it. Consequently, put these clauses into your standard contracts. Back to you after everybody else. Sir? Well, perhaps all the criminal lawyers I was talking about earlier should bone up on their libel and slander actions. There may be more of them in a rational society. I'm not familiar with that particular Kentucky case, so nothing that happened under the law of Kentucky would really surprise me. Since as I understand your case, the fact of the debt had not been established in a court of law. I'm sorry, the fact of the debt had been established by private arbitration proceedings. And I assume it was a long enough period of time ago that such arbitration award was not enforceable in the courts. Of course, if the courts of the coercive state do not have to recognize the existence or the legitimacy of the arbitration award, then to publish a defamatory remark upon someone's credit would, if it were in writing, be a libel upon him and subject you to the usual libel laws. Now, I don't know, I can't predict what in a rational society would happen in such circumstances, but I can tell you what happened in Kentucky wouldn't happen. I would expect that either the fact that a court or an arbitration board did establish the fact of the debt would either provide an affirmative defense on any action for the libel, or would render it a privileged defamation. Probably the first would be the easier way for the courts to resolve it. And I'm sorry that I jumped right into that word compulsion, considering how it rolls so trippingly off the politician's tongue. Because I've been so wrapped up in this huge review of compulsory education laws, I'm afraid it slipped out like that. Let me clarify what I meant. I did not, of course, mean the present horrors under which children are kept in custodial rather than educational institutions. What I did mean, and I'm sorry that it was not clear to you because I should have made it clear, was that those who create a child voluntarily undertake an obligation to that child. If, for example, you have a child in the heart of the Congo jungle, I do not think it is unreasonable for me to say that you have an obligation to teach him how to hunt the lion, or to do whatever else is reasonably necessary to enable him to make his way in the world. Now, what is reasonable under these circumstances, damned if I know. I am very glad that I am not interested in becoming a judge, because they are going to have a whale of a hard time. I do not know either the wisest way to enforce such a concept. I can't see a 5-year-old kid bringing an action in court in case a parent didn't want to educate him. The question is what, leaving aside the adjectives, what makes me think that it is metaphysically possible for someone beside the parent and his child to know what is best in bringing the education to him? Yeah. Well, I'm sorry that you got that implication. I am not, and did not mean to imply that others may officiously and without cause stick their nose into your business. Certainly not. I wouldn't want that accusation to be made of me. What I am concerned with is the admittedly very rare occurrence of the parent who is either too stupid or too lazy to take care of his child. Surely it would become, on principles of, if nothing else, of justice, that if I see you not feeding your child, permitting him to starve, I can poke my nose in. That does not necessarily involve a violation of your rights. You do not have a right to create a child and then starve him. At least I would deny that. Yeah. I agree, a different issue, and I didn't intend to make it a dialogue. If you will accept the general principle, that will be sufficient for my present purposes, that it is permissible for one individual justly, when he sees the abuse of the rights of another, and I contend a child has rights, to interfere. Perhaps he doesn't have to, but he may do so. And if that'll satisfy you until after I get off the podium, we'll go into it for 5 hours. One more, okay. The last time this happened, I said one more, somebody ate me alive. Sir. Damned if I know. It is an academic question, you know. Well, I don't know what would be done in practice about it. It would be a very rare thing, but I am very enamored of the genius of the natural law, and I am very enamored of the justice which seems to arise when rational men quibble over such issues. Family law will be an area of great change in a libertarian society. We will see the rights of children afforded them. I do not base my theory of the right of a child to education upon any necessarily implicit contract between him and his parents, but rather a voluntarily undertaken obligation, let's call it, if you wish, a contract without consideration, that they have entered into. And I didn't mean that particular reference to compulsory education to raise that much of a storm. Thank you for your attention.